Oh, I think we're live. Hi.
One,
Uh,
I,
I am Jeffrey Wernick, and I'm hosting my second pod shoot and my first Fine Points. I'm really happy to be able to have this conversation with Bruce this morning. Um, Bruce, if you don't know Bruce, and I'll have him fill in the blanks that I leave in a very brief introductions. But Bruce worked at the Justice Department's Office of Legal Counsel during the Watergate period of time, and he wrote an extensive memo on what actually constituted an impeachable offense. Um, Bruce also was, I guess, was an assistant deputy attorney general
Associate
during
Deputy
the
Attorney General,
yes,
Associate Deputy Attorney General, yeah,
yes,
involved with
during
judicial
the Reagan
selection.
administration.
Yeah,
You've worked at the, from what I read, and you can confirm what I've read is truthful or not, that you've also been a scholar, resident scholar at the American Enterprise Institute and the Heritage Foundation.
correct.
How would you describe your judicial philosophy?
Well, I think you start out with the words and try to, number one, since the whole goal, Jeffrey, is to seek justice. That's why we have law. Justice is the end game. It's what James Madison described in Federalist 51 is the end of civil society. So, but you start out with the words of a statute or the Constitution. You ask what its purpose is. And if there are ambiguities, you try to construe it in favor of justice. Now, justice, to be sure, is not as clear as mathematics or Newton's laws of motion. But we have a sense that it means that everyone should be treated according to only two criteria, character and accomplishments. And we try to have everyone equally treated under the law. So those are the basic precepts that I utilize in characterizing philosophy of interpretation.
Would you say that many of those that have been the quote conservatives appointed on the Supreme Court have basically described themselves as somewhat being textualists and originalists? How have most of them, when they've described their own judicial philosophy, how have they described themselves in their judicial philosophy?
Well, that's certainly true in terms of self-description. I believe, go back to 2015, Elena Kagan, who's a former dean of the Harvard Law School. She was a Democrat at the Justice Department before she was elevated to the U.S. Supreme Court by Obama. And she described herself, she said, we're all textualists now. Well, it's easy to say. Even the devil can quote scripture. But right. When it comes to hard cases, they abandon textualism at the drop of a hat. And I believe the clearest example of that was on July 1, 2024 of this year, when in Trump versus the United States, they abandoned any reference to the text of the United States Constitution. Said, the United States president has basically de facto or de jure immunity from any crimes that he commits while in office. Now, they said in some context it was just a presumptive immunity, but the cost of litigation immunity is so enormous because you have immediate appeals that it's the equivalent of giving the president of the United States a shield from the criminal law for any actions in office. Now, think of that, Jeffrey. Is there a single word in the Constitution that justifies such a rather astonishing conclusion? The only reference to immunity in the Constitution is for members of Congress. It's called the State Clause in Article 1. But there is no immunity in Article 2 for the president or executive officials. There is no immunity in Article 3 for judges, judicial officials. Judges have been prosecuted regularly for bribery or otherwise. I remember Supreme Court Justice Abe Fortas, if he didn't resign, was going to be subject to criminal investigation by the Justice Department for various alleged acts of corruption relating to financing and Lewis Wolfson. So how did they come up? They're all pledging their textualists, and they just invented this, summed it into being out of thin air. That's just one example, but there could be others as well. Another is the Fourth Amendment. It doesn't create any, it says that there shall be no unreasonable searches and seizures. They say, well, if you expose anything to a third party, like a bank or your internet provider, then it's free game. There's no requirement at all that there be any reasonableness standard. The government can come in and conduct fishing expeditions. And that's why, as we speak today, Jeffrey, the United States government can intercept all of the so-called not yet guilty. That's an Orwellian phrase that Michael Hayden, the former CIA director, has used. The not yet guilty, which is basically most of all mankind.
That's all. That's all of us. We're not yet guilty.
Yeah, we're not yet guilty. How they know we're not yet guilty? Well, but hey, that's in our destiny. Maybe they're soothsayers, they're palm readers. They know we're going to end up in jail or something. But that's why they've destroyed also the Fourth Amendment by going and destroying the text.
Isn't the first or second, when they list certain things that are, things that should not be searched, without proper due process and without proper subpoenas or warrants, isn't one of the first things mentioned are people's papers?
Yeah, the personal, exactly. Papers and effects.
Correct.
Persons, houses, papers, and effects cannot be searched, without a probable cause warrant. And that's just out the window. I mean, the court has authorized the investigators to do virtually everything. And again,
I guess the philosophy right now is that that whatever the government asks, they then must have probable cause, and that's the assumption, is that they have probable cause, and that should not be doubted, that whatever they ask, they must have probable cause to ask it, and nobody should actually ask and inquire about whether that probable cause actually exists. They should just be taken for granted that they have probable cause to ask for whatever they want to ask and to get whatever they want.
Yeah, and it's really a stunning assumption, because every day we know and see government lies all the time about what they're going to find. Like they had probable cause to believe weapons of mass destruction in Iraq, right? It isn't there. They had probable cause to believe you published the Pentagon Papers. The sky would fall. It didn't get published and nothing happened. So the government lies regularly. In fact, it's probably the greatest source of disinformation, of all other outlets, private combined. So why would the Supreme Court indulge the fact that, the government is always telling us the truth? Indeed, it's a very ironic piece of history, Jeffrey, that going back to the very first state secrets case after World War II is called United States versus Reynolds. And there was a crash of an airplane that was a surveillance plane. And the wives of those who had been killed brought suit, claiming that there was negligence. And the Secretary of Defense at that time lied in an affidavit saying, no, if you actually do this discovery on the reason or the cause of the accident, it'll disclose secret spying information that the Soviets will get. It was a complete lie, but the U.S. Supreme Court said, well, you just have to take the affidavit at face value. Threw the case out, right? Now, some 2 decades later, the actual accident report that had previously been classified was declassified and was on the internet. So the wives stumbled upon the accident report, which said no, had nothing to do with classified information. Clearly, there was negligence in not keeping the aircraft in proper condition. So they go back to court and say, wait a minute, no, there's fraud on the court. Secretary of Air Force lied. Court said it's too late. Sorry, see you. So, but anyway, this is the first case on state secrets the Supreme Court has lied to, and they continue to accept this absurd assumption. The Supreme Court or the government tells you they have cause to believe in XYZ, we have to swallow it.
I think maybe I could be very confused, or misinformed, or disinformed. But my understanding that the Bill of Rights was added to the Constitution to reinforce the fact that government should be limited, and the role of the courts were to make sure that the legislative or executive branches did not overstep their constitutional responsibility, and that and that really the tie should go to the people and not to the government. So that's kind of what my impression of the intent of the document, and from my readings of the people who were involved at the Constitutional Convention and the correspondence that existed between the key authors of the Constitution. So would you consider that a reasonably accurate description, that really the intent was to limit government, and to give the preference that if in doubt, the ball always goes to the people, and not the presumption of the benefit of the executive or legislative branches?
That's absolutely correct, Jeffrey. And you'll notice that the Bill of Rights, it's all negative, what the government can't do. The government can't do this. The government can't do that. It does. There's nothing in the Bill of Rights that authorizes the government to do anything. It's all negative. And in fact, James Madison, who was the primary architect of the Bill of Rights, said on the floor of the House, which he then was leading, that, yeah, that independent tribunals of justice could be trusted, to check the executive and legislative branches from overreach. They understood that. That the political branches were likely to abuse power. And Madison was very prescient. He was one of the few in all history, Jeffrey, who combined a towering intellect. He had the biggest library in all of the United States at the time, with practical jaw-to-jaw experience with politicians and all the nefarious venal motives, because he began serving in legislative offices at age 25. So he wasn't an ivory tower scholar. He saw the need to pit ambition against ambition, the need to make liberty the glory of the nation, not the power of the government. And that's why, the tribunal, the separation of powers, which is also his handiwork, was established. And so although today it's viewed as a pejorative to say, oh, government gridlock is separation of powers at work. It's trying to prevent the government from doing things because they don't have enough of a consensus. It means then you shouldn't do it. And I think, Jeffrey, there's been this huge misunderstanding about not only the Bill of Rights, but about the philosophical understandings and precepts of the Constitution itself. It's not about pure majority rules. Majority has its say and a dominant influence in some cases, but we do not have pure majority rule. Otherwise, we have 1,000 tyrants instead of one, replacing King George III. That's what Thomas Jefferson said, that the whole idea is no, majorities have an important role, but you need a consensus beyond simple majorities in order to move forward. That's the way you protect minorities and liberties, the right to march to your own drummer. And today it's just thought, oh, you block anybody from the majority from getting their way. Oh, that's bad. No, majority can be tyrannical every bit as much as a Caesar.
I think something that I like to point out in some of these conversations is that first, the founders and our constitutional document had contemplated that really the federal government would be very limited, and at that point in time there were 13 states. Now we have 50 states. So the concept of having 13 states have to reach a national consensus on a lot of issues was antithetical to the original document. So how much has that compounded the problem? That you have 13 states who really don't have to reach consensus on very much because the federal government did very little. Now we have a situation where 50 states have to form a national consensus on almost every issue because almost every issue has become a federal issue. And so how much this has compounded the fact that really most of the federal government just, until the Fed was created, and I say that 1913 is the year that liberty died, because it was the year that we had the passage of the income tax. It was the year that we created the Fed, and it was the year that we had instead of state legislatures selecting senators, people who would represent the state as on the Senate, that we nationalized essentially the elections of senators by making it done by popular vote of the state rather than something done by state legislators who could then make sure that whoever they appointed represented from their perspective the interests of the state. So prior to 1913, the size of government spending on state, federal, and local level was under 6% of GDP, and Thomas Jefferson, when he was president, and federal government spending was just a couple of percentage of GDP, he thought that was too big a government, and he devoted himself to cutting government spending along with his Treasury Secretary Gallatin. And now we have state, federal, and local spending that's approximately half of GDP. And then when you think about how much more the government intervenes with our lives through administrative agencies that didn't exist for the first 100 years, more or less, depending upon which administrative agency you're talking about. In some are not even 100 years old, in the interference of the government and the federal government in our lives, and as witnessed by how much money is invested in lobbying, and because of how important the decisions made in Washington, D.C., is that how much of our polarization, is a consequence of decisions that should not be federal decisions, that should be left, to the states, and therefore they can be argued on a more state or local level, rather than making every issue a national issue that people have to fight about.
Yeah, well, I think that's largely true, Jeffrey. Up until 1900, there were presidential campaigns were run on the idea, what are we going to do with the surpluses? And this was even before the income tax. We were running surpluses just based upon tariffs and excise taxes, because the government still was reasonably small. But the real accelerator into the kind of dystopia that you've described was our becoming an empire, starting with the Spanish-American War, slaughtering all the Filipinos who thought we were coming with self-determination rather than conquest. And we turned slowly into a warfare state. Our national debt climbed during World War I from 1 billion to 30 billion, a 29, I don't even know what the multiple increase is, from 1 billion to 30 billion fighting World War I. And it's just, the trajectory has continued since that time. And so with a warfare state.
And after 1913, after the Fed was created.
Yeah, right. And the income tax, that's how we were able to do that. And our Secretary of Treasury said, hey, there's no way. It's kind of funny.
It's the same story in history, is that to fight wars, you got to debase money.
Okay? Yeah, exactly.
So you get money from the people two ways. Yeah. There's only a limited extent that you can tax people. So to the extent that there's a limit to how much you can tax people without people revolting, is that you debase money. So you either take money from people's pockets directly, or indirectly through an inflation tax by debasing their money. And so in order for there to be a warfare state, there needs to be a fiat paper money regime to fund a warfare state, because the odds are that people are not willing to pay the taxes to support people will not pay the tax to fund an American empire. Yeah, so what funds the American empire is fiat paper money. Without fiat paper money, there would be no American empire, because if you would have asked, I think if you would have asked the American people, we need to spend $8 trillion in a 20-year war in the Middle East. Okay, we're gonna now have a special surtax for every American, because it's an existential threat to the American people. All this going on in the Middle East is an existential threat. So we're sure each of you are going to pay your pro rata share of the $8 trillion to defend America and freedom and liberty. And you all believe that if we don't spend this money, that you'll be speaking some other foreign language, and every one of your rights and liberties will be taken from you. Yeah. So I don't think that would have been. I don't think anyone would have won the presidency promising to tax the American people another $8 trillion over a 20-year period of time, to fight these wars that ended up not producing the outcome that was promised in any one of the cases. The Taliban controls Afghanistan. Iran now has more influence in Iraq prior to our intervention than after our intervention. Assad still is firmly in place in Syria, and Israelis and Palestinians continue to kill each other. So, I don't know what we got for our $8 trillion. Well, I do know what we got. We got a big IOU that we're going to pass on to a future generation. And that eventually, this expression goes, come home to roost. So fiat money has enabled all of these, the warfare state.
Yeah. In fact, Jeffrey, William McAdoo, he was President Wilson's son-in-law, the Secretary of Treasury in World War I. When it came to finance the war, he said, Mr. President, no way we can raise the taxes. We got to do Liberty bonds and get the Fed to go sell these Liberty bonds, right? And so that's why we ended up with a $38 billion debt at the end of the war. And you remember Iraq? Donald Rumsfeld, oh, Iraqi oil will pay for every penny of the intervention, right? He was off by trillions of dollars. So the government just lies about it.
There was a head of the economic team at the Bush administration, a guy named Lawrence Lindsay. Lawrence Lindsay, in an interview, when he asked what would be the cost of the of fighting the Iraq war to the American people, and he had estimated the cost at about $300 million. And for saying that, he was fired from his job because he didn't go at $300 million. Obviously, ended up a decimal point of what actually it cost. But he didn't go along with the line that yes, the war would pay for itself. So as today, basically, as that's what's going to happen with funding Social Security and Medicare. It'll pay for itself as well. So all these things is, don't worry, it's just Hakuna Matata. Everything will work out fine. It'll just pay for itself.
Yeah, I think Jeffrey, if we think in kind of a larger scheme of things, what the underlying fuel for all of these deformities of the Constitution and of the idea that liberty is our glory, not dominating the world, is the fact that the American people generally, and certainly the two major parties, they've decided that, liberty has to take second seat to empire and telling everybody else in the world, hey, we're better than you. We can bomb you. We can kill you with drones. We can do anything you want. And it's a very retrograde understanding of what our country was built upon, which was the opposite idea, that we didn't race abroad in search of monster to destroy, that our glory was liberty in the march of the mind, not the march of the foot soldier. And Abraham Lincoln said as early as 1838, no Napoleon, no Genghis Khan can ever cross the Atlantic and destroy us. It'll come by suicide, because we'll destroy ourselves if we don't recognize our underlying values.
Oh, Madison made the same point also.
Yeah. If you see instruments to crush force abroad, comes back home and kills liberty. Yeah, it's the same story over and over again throughout history.
During the Depression, to not have us feel so depressed, FDR had an ideology I did not necessarily agree with at all, but as far as being inspirational in his fireside chats, telling the people who at that point in time had some fear about the circumstances of the world, said, the only thing we have to fear is fear itself, and now we have candidates that tell us we should be fearful of everything. We turn fleas into elephants and say, my God, what's going to happen? I mean, right now, the fanaticism against China, China is asserting a sphere of influence, for good or for ill, that we've asserted for 200 or more years with the Monroe Doctrine in Central and South America. And suddenly we think if they want to control the South China Sea, it's an imminent danger to us. It's called the South China Sea. Why? Because it's adjacent to China. We're stunned that they ought to think that they want to control South China Sea or Taiwan. Listen, Taiwan is like Cuba is to us. Like we tried to kill Castro. I don't know how many times we controlled and blockaded and isolated Cuba, intervened in the first Spanish-American War, intervened afterwards. So I'm not applauding this, Jeffrey, but we take what we do is now imitated by other countries. And then we take that instead of, as Oscar Wilde said, that's the greatest form of flattery is imitation. We say, oh my gosh, these people must be horrible, horrible people because they're doing what we do. Right? But wait a minute. If you just kind of leave, it's not going to make a perfect world for any means, because mankind has made a crooked chamber. Nothing's going to make a perfect world. But at least it gets out of this madness is leading us to a conflict, if not war and nuclear exchanges with China. Over what? I remember there was a possibility of nuclear exchanges with China and Quemoy and Matsu in the 1950s. And the only thing that inhabited Quemoy and Matsu was a few turtles. And we're going to go to destroy mankind over that. It's just deranged. Well, I think it's deranged and rational. It's deranged if you're looking at it from a rational perspective, but it's also another form of rational perspective is that our own government has done such a bad job that instead of blaming themselves, they need to attribute the blame to somebody else. So this is all distraction, with how bad it. One is no government could do a good job if you decide that you want to have, quote, a somewhat democratic system where people don't necessarily, where the country is basically ideologically divided on many important issues, and to think that we can resolve all these issues on a federal level. The only thing that we resolved is that we're incapable of resolving it. So what we do is we print fiat money to figure out how we can satisfy those that complain the most effectively. So we don't really solve problems. We alleviate symptoms while we let the problem grow. So it seems to me that that's, and we might be getting to an end point of that, that no longer works. And then what do we do next? Because American people have not learned, again, how to sacrifice over, actually, instead of getting more, having to give up things, such as benefits that they hope to have, without consideration of who's actually going to pay for those benefits. But I wanted to ask you, James Madison said we have property in our rights and rights in our property. Mm-hmm. So how much, to the extent that this is what the main author of the Constitution had to say about his definition of what it means to have inalienable rights. So if somebody was looking at the text and also trying to get to what the intent of that text was by looking at the words of one of the main authors of that text and said, this is how I would define rights, then would any encroachment of our inalienable rights be a taking that really the government should have to compensate for, just as if they took our house or any other, physical possession? Isn't the definition of our rights that should not be taken from us? Isn't Madison's definition of that much more expansive than how it's interpreted by the courts in its definition of what is a taking?
Yes, I mean, the gist of what the court has said, Jeffrey, is that unless in its regulatory sphere, the government prevents any economically useful assertion of or exercise of rights over your property, it's not a so-called taking, so, but it can destroy 90% of the value of what you can do by very onerous regulatory restraints.
But where is that interpretation in the text or in any examination of the intent?
There's nothing. No, the Fifth Amendment says that a private property shall not be taken without just compensation. But they say that it's not a so-called takings, unless you destroy 100% of the economic value of the property rather than 95%, which I think is really crazy. Because if we think about this, that the idea behind public domain, eminent domain, is that, hey, there's certain things the government does to help everybody, right? So that's the power of eminent domain that's exercised to build certain infrastructure, place our missile systems or whatever. Well, if it's intended to benefit everybody ought to pay for the cost of the benefit, which means the person who loses out because their property is encroached upon, whether it's lost half of its value or 3/4 or a quarter, ought to be fully compensated because everybody else is the beneficiary. There shouldn't be any free riders. That's the idea behind just compensation. No free riders. The government needs to pay if they're trying to piggyback on other people's property. But, the court looks at it and says, and again, it's so crazy. I mean, I could understand being worried about just compensation when you had a national budget of, a couple of $100,000, a $6 trillion budget. We print the money every day. I mean, the idea that it'll shut the government down if they have to pay for this stuff is absurd. But it's just this deference to government.
Where I'm going with this question is because one of the topics that was supposed to be a surveillance state. To the extent that the courts, in my opinion, and I think you agree, but I don't want to put words in your mouth, is that the court's interpretation with respect to the third-party doctrine I believe is a violation of the principles embedded in our Bill of Rights, because we have to have an interaction with a third party that requires information from us uniquely for that relationship that we're compelled to give. That does not mean it's essentially the same thing as making that information public. Which is basically the interpretation that the courts have made to it, at least that the government has access to it all. Well, if the government has access to it all, why would not anybody under the Freedom of Information Act have access to the same information if it's already in the public domain? Why wouldn't everybody be entitled to it? So I don't understand if it's private. No one is entitled to it other than the person you exchange information. If it's considered in the public domain, then if it's in the public domain and the government has a right to it, why wouldn't everyone else also have a right to say, I can call up AT&T and ask, can you tell me where Bruce, the phone calls Bruce have made? Why wouldn't I have the same right to do that if it's deemed as being in the public domain as the government has to AT&T? Why would they have to? What gives them the right for the government to ask that question without a warrant, and not me have the same right to ask AT&T the same question?
Well, I don't know whether I would say it's a satisfactory answer. Is the Freedom of Information Act creates exemptions from putting documents in the public domain
But the argument of the third-party doctrine is that the government can get the information because it's in the public domain.
That's correct. But when it becomes
debate. So if it's in the public domain, why is only the government the only entity that can get the information? Since the third-party doctrine has said it's in the public domain, and that's why the government can get it. If it's in the public domain, why can't I get the same information that the government can get from AT&T if it's now considered non-private information?
Because the Freedom of Information Act says, as long as they say, as the government says, well, it could be think of this irony, Jeff, that under the Freedom of Information Act, one of the justifications for the government's withholding information is that disclosure would unreasonably invade the privacy of an individual. But they can invade the privacy to get the information for itself. But then afterwards say, if we disclose it, it can invade privacy, and therefore we conceal it. A second exemption relates to any internal document relating to law enforcement. And today, with all the thousands of laws on the book, they always claim, it relates to law enforcement, so we'll withhold you. Now, of course, Congress can change the exemptions, but, we have a very anemic, venal Congress that won't do anything if the executive branch doesn't take.
One is what the government can do once it gets the information. The other is the getting of the information. So in the getting of the information, I don't understand the concept that something is in the public domain, but it's only in the public domain for the government to access, not for anybody else to access. So is the third-party doctrine giving the exemption from the government to get information that's still private information that only the government can ask for it? Or is it in the public domain and the government has an access to it because it's in the public domain? My understanding of the third-party doctrine is the arguments have been made by the court that by sharing that information, it's now in the public domain. So if it's now in the public domain, why can't I call if the government can call AT&T and ask about who Bruce Fein has been calling lately? Why can't Jeffrey Wernick call AT&T since it's in the public domain, since it's in public information? Okay, why? I'm part of the public and it's public information. And if it's in public information, that means the public should have access to all public information, not just the government should have access to what's considered public information.
Yeah, well, they're two different. Let's take the AT&T example, Jeffrey. They're two differences. One, the government can issue a subpoena. Private individual.
They're getting this without a subpoena. They're getting this without a subpoena.
They know the government will issue a subpoena because the subpoena doesn't require any probable cause standing. The second reason why AT&T complies, and all these mega companies, because they got multi-billion-dollar contracts with the government. There's no way that they're going to do anything but say how high when the government says jump. Now, remember, in the aftermath of 9/11, the United States government went to AT&T and said, we want to intercept. This was all the terrorist surveillance program. This began what became the nightmare with the warrantless surveillance of the not yet guilty. And AT&T said, hey, the government could sit in one of its complexes and monitor every single phone call in the United States, internationally in the United States. They said, okay, go ahead and do it. We'll pay for it. Yeah. Because why? They have all these huge contracts with the Defense Department. They're going to alienate the government. That's their bread and butter. No way.
Yeah,
these governments will do that.
When I'm trying to go with these arguments, I understand your answer, but I'm trying to put how absurd the proposition is.
Yeah.
Absurd the proposition is the courts have deemed this as public information, but it's public information that's really only shared with the government, not with the public. So it's not really public information. The whole thing is kind of a farce. And in my point of view, is that any information that the government has obtained about me or any other human being, without a warrant, is an unreasonable search and seizure. It's a deprivation of my rights or any other person's individual rights, and it's been a taking. Going back to Madison's statement, we have property rights and rights in our property. So it's our property rights that have been stolen from us. And to the extent this property rights have stolen from us, then there has to be compensation associated with, with the act of getting access to information from us, that where any piece of information the government has gotten regarding anyone without a warrant, people should get compensated for. And if the compensation was meaningful, like in many torts where, you want to have the fine consistent with discouraging the behavior, that, it would be a way to make sure the government doesn't do any of this stuff if it had to pay a lot of money for all its violations of these things. It's the fact that there's no consequence associated with breaking all these laws, with obtaining all this information, and the courts reinforcing, instead of protecting our civil rights and civil liberties, the courts are protecting the government's intrusion onto our rights and civil liberties.
Yeah, not only I think it may even be worse than what you've described, Jeffrey, because we, the taxpayers, are paying for the government. We're paying the salaries. We're paying for the infrastructure to spy on ourselves, right? So we get no compensation. The government gets, their employees and the investigators get nice salaries from our tax money. So it's but all I'm just saying there, as a lawyer, Jeffrey, I think a layman doesn't understand. There are many things in the law that make no sense at all. It's if you've read Oliver Twist, you remember a famous phrase from Mr. Bumble. If the law believes that, the law is a idiot. This is the British common law believe that the husband controlled all the wives. It's okay. So the law is filled with that. And you described, the illogical nature of a lot of this reasoning. Well, that's what the law oftentimes does, because the law.
It's logical in the sense that that instead of providing a check and balance on each other, they're reinforcing each other's perks and privileges. So it's logical. It's illogical to the extent that they're all protecting and reinforcing the perks and privileges that they enjoy. And in order for them to preserve those perks and privileges, the less each branch is a threat to each other, the more they each can preserve that. The concept of why, initially this was designed that there'd be checks and balances, but the actual incentive is to not have checks and balances, except checks and balances on the people, not on the government. So this is actually a logical outcome, because every organization is biologically programmed to thrive. So what makes each one of them thrive is accumulating power and not having and removing all checks and constraints to that power. So it's our job, that we do a lousy job at it, in providing checks and constraints, on the power. And now that we have this, where the system essentially reinforces it, and it reinforces it mostly because, we have not fought to preserve our own freedoms, and we've accepted our own inalienable rights to now be, privileges doled out, according to government fiat, like government fiat of paper. Government gets to determine, what privileges we have, but they've completely eradicated the concept, with the support of the court, of the existence of inalienable rights, in my opinion.
Yeah, I think, Jeffrey, what underscores your point is to go back pretty far in history, but to one of our greatest days, July 4th, 1776, Independence Hall, Philadelphia. They're 56. They signed their death warrants for life, liberty, and pursuit of happiness. They are called the 56 signatories to the Declaration of Independence. They knew they didn't win. They're going to be hung for treason. 5 of them ultimately were tortured and died, right? But they didn't flinch. They had courage, and they said, yeah, it's worth it. Could we find 55 today, 56 today to stand up? And would they do that? Jeffrey, I think we'd still be looking like Diogenes for an honest man. We don't have a culture that would do that anymore because we've lost those values. We've lost those commitments to the idea that, yes, individual rights, liberty, marching to your own drummer, being courageous, seeking justice, not just accumulation of riches and creature comforts. It's a bygone era. Those ideas are museum pieces today. So we have a very docile citizenry. I know a Congressman Thomas Massey of Kentucky said, Bruce, talking to my constituents, talking to other members of Congress about the Constitution, it's like reading Shakespeare to cows. It just doesn't resonate. So it's a huge, huge problem. Then the founders understood, Jeffrey, without a highly educated populace, there's no way the system could work because the populace wouldn't understand the importance of the checks and balances that you've described, ambition against ambition. Most politicians are sociopaths. And the very first State of the Union address of George Washington is, we've got to get after education because that's the prop of our self-government. And today, education is it decayed so far below anything that resembles learning critical thinking, you kind of laugh in despair. So we don't longer have a culture that knows any of this stuff, and they're not willing to defend it. So presidents can think July 23rd, 2019, President Donald Trump, these are his exact words. Then I have Article 2, where I have the right to do anything I want as president. Sounds like King George III. But you're the president.
I think the Supreme Court just confirmed that his interpretation is correct.
Right.
He just confirmed that.
Yeah.
So I don't know what text they cite. I don't think they cited any text.
No, they didn't cite any text.
They didn't cite any text because there is no text to cite. They invented the words. These textualists, originalists, ignored the whole conversation there was at the Constitutional Convention, which was very limited, regarding presidential immunity. Whatever conversation had, that basically was deemed that the president should not have any immunity. Otherwise, they would have put those words in the text. Yeah. So if they would have studied people's words and discussions about who should have immunity and what the final text would come out, they know that this is all invented by them.
Yeah.
So the question is, what outcome did they want to create by their own invention? And I think one question I read that was asked is, do you believe that the Supreme Court justices actually believe in the Constitution itself?
No, I believe that they believe in empire. And they'll do everything where power goes. They will ratify power, not justice, which is the opposite of what their mission is about. And that's why it's not just, if Trump was just an aberration, it's as horrible as it is. It's not an aberration. The court across the board, they never intercede on those illegal wars, the illegal surveillance under national security, the state secrets privilege, the torture issues. They run away from it because they're there to ratify an empire. Not checks and balances, because you can't have an empire with checks and balances. You got to have one commander. You got to have a Caesar to run an empire, right? Okay, who's the Caesar? Well, it's going to be president of the United States. The Caesar used to be kings and queens in Britain, what we thought we got rid of in 1776, but now they've returned because we decided we want to better the instruction of the British Empire, as stupid as they were. And so, no, I don't not believe the Supreme Court is there, and they think that they're supporting the Constitution. They're supporting empire because they've grown up. They've been living in this bubble from day one of their lives. At least, since we went into Korea without any declaration of war, and Harry Truman said, it's a police action, a police action, 3 million Chinese, brink of nuclear war. It's a police action. We don't need to go to Congress. Supreme Court, no, they don't. There's nothing challenges the constitutionality of the war. They did slap Truman on the wrist on the steel seizure case and saying he couldn't seize steel mills, but he could go to war and send people to die in huge numbers. But he couldn't seize a steel mill. So that's just a huge problem we have. And how we go back and get true education anymore, so they understand what the obligations of citizenry are. I don't know how we do that. Given all of the decay in our, the teaching core and the students and the TikTok and the diversions and whatever. It's truly stunning. I'd be the last one, Jeffrey, to defend the craziness of the United States government on saying, well, TikTok's a national security threat. It certainly is not. But it's amazing to me that we don't have teachers and parents who can't stimulate their children to be more engaged in learning and wisdom and character, to stay off of TikTok because they're going to read Aesop's Fables, Greek mythology, the child's version of Shakespeare. I mean, that's not very hard. This other stuff is so boring after 3 minutes. I mean, how can you get excited after some 5-year-old jumping up and down and putting lipstick on? I mean, that's pretty hard to do. But we've fallen down on the job.
I think that many of the founders in their writings and correspondence amongst and between each other talked about the importance of us not only being an educated and informed public, but a virtuous people. Yeah. So I don't think a virtuous people, runs the type of fiscal deficits that we run, where they're passing, where they're willing to accept taxation without representation, where they spend money for their benefit, and it's. I think a guy named Sachs defined this concept of something called odious debt in the 1920s, and his definition of odious debt, was debt basically where the government accumulated debt, and where the people who benefited from it, were not responsible for paying for it, and therefore the subsequent generation, to the extent that the money was spent in a way without their consent, where they're past the obligation to pay it off, where they're not direct beneficiaries of that spending, they could deem that debt odious debt and therefore have no obligation to pay it back. So I would assert that almost all our debt is odious debt, and probably future generations have no obligation to pay it back, because they're going to see no benefit associated with, it's not like we're spending the money on an infrastructure that will last for a long time. We're not spending it on infrastructure, and only a small percent of it is spent on, I guess not defense. Most of it is spent on offense, not defense, with respect to military expenditures. It's not like we're spending only enough to preserve, our own independence. We're spending a lot more to really encroach upon the independence and sovereignty of other nations, rather than protecting the sovereignty of our own nation. So I think most of the debt is odious, but of course the government has the weapons and the prisons and the police state and the surveillance. So at the end of the day, if you say that publicly, you'll get put in jail, and for the fact of thinking that you can repudiate the debt because you didn't incur it. So I don't know what we could expect of a generation like our generation and the one that came right after us, to actually teach the kids anything about morality, because we're either an amoral or an immoral people, and there's no evidence of morality, because a moral people, would not live off of fiat money, and would not live off debt, and a moral people would not ask the government to do so many things on its behalf that it should be doing it for themselves. So I think there's very so given the fact that we were expecting to be virtuous, and how the founders defined virtuous behavior, we failed the test, and these are the consequences of us not being a virtuous people. So I don't know why we should expect that we have anything to teach a younger generation. I think the most thing we have to teach the younger generation is what not to do, rather than what to do, because we've set a terrible example.
Well, all of that being true, Jeffrey, they still have history. Because I get my inspiration not from current generation.
Assume if they get history, they're going to get history in one or two places. From home, they're not going to get it from home because their parents are stupid, okay? Yeah. And they're not going to get it from the schools because the parents don't police the schools sufficiently well to make sure that the kids get a good education in schools. So basically, parents have basically abnegated their responsibility of really creating. The University of Chicago has I don't know if it still has, they had this committee on social thought, and within that committee on social thought, there was a program called Politics, Economics, Rhetoric, and Law. And what was the inspiration of this program? The inspiration of the program was from insights from Benjamin Franklin. And Benjamin Franklin said, if we're going to be a free, liberty-loving, freedom-loving society of people who are essentially self-governed, that we have to be educated. And there's an infrastructure of education we need to be a good citizen. And to be a good citizen, we need to understand politics. We need to understand economics. We need to know how to engage in conversation, which is rhetoric. and I'm not talking about the type of rhetoric we witnessed in the debate, because that's just sheer stupidity on both sides, vacuous slogans, and mean-spirited comments. And we should know the law, because the law is the infrastructure for society. So in order for us to preserve this constitutional republic, this limited government, this exercise in self-government, that citizens had to know and be able to discuss these issues in an informed basis. Okay, so how many people get out of the educational system really understanding politics and our political system very well? How many of them have any literacy in economics? If they had any literacy in economics, they would say, we need 2 more candidates. We got to throw these 2 candidates out now who are running for office because they're economic morons. Yeah. So rhetoric, well, clearly, if you just read social media and read Twitter and stuff like that, obviously everybody has failed rhetoric, because all they know is how to insult each other rather than really engage in any enlightened discourse or agreeable disagreements. And people have.
But Jeff, there is a saving. It's not a saving grace, because you're right. The parents are in default, the educators are in default, but we still have the internet. Because all the great books, all the great literature and history worth reading is out of copyright. You go on the internet, that's what I do. I can get books for free. And to the extent I use the internet, which is not a whole lot, I get emails, but I read and I download things much faster than otherwise. So it's got to be autodidact. Abraham Lincoln was very wise. I mean, no one today could write a sentence worthy of the Gettysburg Address in terms of power and insight, philosophical depth. He didn't spend a day in college. He sat and he read books, right? It wasn't, his parents didn't bring him up to read, and he wasn't enrolled in formal schooling, but he did it on his own, in part because it was encouraged by the climate of the time. His great hero was Henry Clay. So despite all of the handicaps, because it's much easier to do this if you have teachers and if you have parents who encourage you, you can still do it. You have to try. I get encouragement by reading our framers, reading about Socrates, taking the hemlock to emancipate the mind from stupidities and vulgarities and all the other things that infected even Athens at its zenith. Right. Because the large majority of mankind is always stupid and moronic. So they sentenced him to death. The greatest citizen, they sentenced him to death. I mean, they became lobotomized as soon as they gave a sentence to Socrates. And of course, the Athenian empire then crumbled. But anyway, that's available. Now, I understand it may be hard because without peer pressure and rewards from your parents, it's hard to just on your own pick up and read this stuff because you don't get any social reinforcement. You're not heralded by your peers. Hey, you know about the framers, the signatories of the American Declaration of Independence. You understand the Constitution. If you don't know Taylor Swift's latest album and who won the Super Bowl or whatever, you're just viewed as a freak. So it's something that you just have to pick up on your own. Now, is it a hard challenge? Yeah, it is. But it was a hard challenge to create the United States of America. Valley Forge, people suffered way more than we're suffering. The fact that you and I, Jeffrey, can be on this Zoom call right now or the stream set, that wouldn't have been available without people making sacrifices and giving up their lives, at least to create a patina of information and freedom and liberty. I say we, in some sense, are lottery ticket winners compared to hundreds of years ago. So we do the best we can, even though we're confronting 100-mile-an-hour head.
Yeah, I think, the system actually, I think, reinforces conformity and mediocrity. When I was a precocious child and I was reading, and I still to this day read 2 books a week. So I try and read at least 100 books a year. And so when I was sitting in class, and I grew up in a I guess a thing, maybe upper middle class neighborhood. My parents moved into a house that had a good school district, but I found the classes easy. So during class, I would bring books to read, and I wasn't paying attention to the teacher, and I was just reading my books. And when the teachers would ask me to put my book down, I would refuse. I would just say, you're boring me. I have an obligation to be in the seat. I don't have an obligation to listen to you. So I just have an obligation to be in the seat, and you don't want me talking and disturbing my neighbors, so other classmates. So why does it bother you that I see no value in listening to you? So, because I love to learn. The material in the classroom, I had already taught myself.
Yeah.
So sitting in the class, I didn't need to sit in the class to learn material. I had already devoted myself to learn. So instead of being rewarded by the system, I was punished by the system. I actually had to get my grades done by the principal of the school, and because I would get like 95 to 100 on all my tests.
Mhm.
And the teachers would say, okay, you're an A student, but you have an attitude problem. So for class participation, we're giving you an F, and they would try and give me C's. So they would try and give me C's on all my courses. So I said, look, I want to go to a good college. If you want to put on my record that I'm an A student with an attitude problem, that could be honest. But you're telling people I'm a C student when you know I'm not a C student. So I appealed. My mother went to this was in the mid 70s, so there were concerns about budget cuts in the school, and my mother became an activist in support of supporting the school and the funding of the school. So the principal liked my mother, and my mother went to the school and pleaded on my behalf. I didn't do a very effective job of pleading on my own behalf, other than just bringing the test scores and saying, for the objective part of my grades, I'm getting perfect scores on almost everything. The subjective part, I'm getting an F on everything. And this is just unfair to me and my future. And finally, the principal would have to come in and every year have to redo my grades. So wouldn't anger the teachers so much, and also some appeasing of me. I took AP math, and the first test I got a perfect score, and the teachers gave me an F, and I said, can you explain to me why I got an F? The teacher said, you cheated. So I said, how did I cheat? He said, no way you could learn this stuff without listening, paying attention in class. And I told the teacher, you have a very high opinion of yourself. So the teacher, I said, if I cheated, can you tell me what evidence do you have that I either knew the questions that exist, or to show me who else around me got a perfect score? So who did I cheat from? So do you have any evidence? He just said, no. Since you didn't listen to me, there's no way that you could have gotten this score. I said, you're supposed to be a math teacher and have some logic to you. So I don't understand the logic of that, thinking the fact is that nobody can learn math on their own, and that unless I listen to you, I'm incapable of solving calculus problems.
Yeah.
So I challenged the teacher to give me an oral exam on the spot. I just said, just test me now, but let's do this. Test me now on anything that I need to know during the whole semester, not what this exam was on. This is the beginning of the semester. Anything that's supposed to be covered in this semester, okay, even if it's the last week of the year, okay, test me now, test me orally under this thing, okay? If I prove the test, you apologize to me in front of the class, and you give me a perfect, and you confirm my score, but you have to give me an apology as well, okay? But the other thing you have to do is, if I pass the test, if I fail, you can give me an F for the whole year, okay? If I prove I don't know this, just fail me for the whole year. Just flunk me out of the class. But you have to take a risk as well. If I can pass your test, you have to quit. So if you're so sure I don't know anything, you're risking nothing by giving me an oral exam now, because you're telling me I can't know anything that you didn't teach. I don't know the questions you're going to ask. You can ask the questions for the whole course of the year, and so obviously the teacher was back down, still wanted to fail me, but there were stories like that helped the principal decide to. So when you talk about reinforcing, here you have somebody who loves to learn, okay, and the school system is discouraging my appetite and thirst and desire for knowledge. So how perverse is that? That's our society.
It is. We do have, mediocrity is everywhere. And anytime, Jeffrey, you have large organizations, mediocrity becomes the ethos, and you're frowned upon, if you rise above mediocrity. I know when I walk into congressional offices, and I don't ask for anything, I'm just trying to help. Hey, we can write these speeches, we can draft legislation. The staff is terrified because they figure, wow, Bruce is going to tell them stuff that we should have told them we don't know anything about. So instead of being welcome, they don't have to pay me anything. They feel I'm a threat because it'll expose mediocrity, So they're that shallow, and they're that small-minded and mean-spirited. And mediocrity, I say, it's the bane of all large organizations. That's why you can never accomplish anything very stellar that has a group of more than a handful. That's why we did the ultra secret crack over in Bletchley in World War II. They're a handful there. The CIA could never do that today. NSA, no, they can't do anything, because in all these big organizations, mediocrity is the standard. They don't know anything, and you can't rise if you know anything, like you're displaying your own wisdom superior to that of the teacher. And that's a real huge problem. I remember when one of the first times I got here in Washington, there was a vacancy on the Supreme Court. And Roman Hruska was a Republican senator from Nebraska, and he's sitting on the Senate Judiciary Committee. And he's complaining why everybody wants Nixon to appoint somebody who's like Cardozo or Brandeis or Holmes. And he says, well, come on now. Mediocrity needs representation too. We can't all have excellent people on the court. And he said it without embarrassment, Jeffrey. We need mediocrity. It needs representation because it's the majority. Oh my God. Anyway, it's where we are. I don't know how we cope with this, Theo, but
I have one other question, because we've been in an hour, a little longer than an hour now, but I have a question that I have curiosity about.
Yeah.
And maybe I'm the only one curious about this thing. If I think about like the role of the states in controlling the ballot and who is on the ballot, that we had a decision not too long ago, Trump versus Anderson, with respect to the fact that the state felt it had the right for, and they deemed Trump guilty of inspiring an insurrection, and therefore they deemed him ineligible to be on the ballot. The Supreme Court basically said you got to put him back on the ballot. Now we have Bobby Kennedy looking to be removed from the ballots. So the question is what role does the states have to determine who gets access to the ballot and who gets off the ballot? Or basically, has the Supreme Court deemed that if it's a federal election, that only the Supreme Court can do that, since it's a federal election, even though it seems to me the point of the Electoral College is that the states are electing the president. So it's not a popular vote, it's electoral vote. And therefore, it's an electoral vote with each state determining which candidate gets those electoral votes. It seems to me that's not really, a union, but a federation of states, where each state is acting independently of each other state and making its own judgment about who that state electoral votes are going to support to vote for the president. So it's not really a federal issue, it's a state issue, is what it would seem to me to be the case. And it would not be a federal issue, even if it's a federal office, that the Electoral College made it a state issue, not a federal issue. That's my interpretation, which could be wrong. So and to me, it's an interesting question now regarding, Bobby put so much effort to get on the ballot. Now he wants to get off the ballot, or some of the ballots, not all the ballots. In some cases, the ballots have already been printed out and sent out because there's early voting and mail-in voting and things like that. So at the end of the day, who has the judgment? Maybe according to the ruling of Trump versus Anderson, maybe the only people that can opine on this is the Supreme Court and not the states, because it seems to me that the Supreme Court has said basically the states have limited control and autonomy over who's on or not on the ballot.
Yeah, well, the court's decisions describe the Electoral College and presidential elections as a hybrid of federal and state intersection of
But
sovereignty.
that's not true. I think that's a lie.
Okay, but I'm just telling you what I'm the messenger.
Where in the Constitution? Where did the Constitution define it as a hybrid system? Where's the text?
The court articulates that in casting the ballot for the president, which is a federal office, in that role, it is acting in a federal capacity. But in its role of deciding,
if there was a popular vote, I would agree with that, but it's not a popular vote.
No, but it's a popular vote now to elect electors, right? And so the court says that the process of electing an elector to perform a federal function is a state process. But you're right that and that's why the decision in Trump v. Anderson was so odd. The Colorado decision that was under review by the U.S. Supreme Court applied where? Only in Colorado. The Colorado decision didn't force any other state to remove Trump from the ballot. It was a decision made because the jurisdiction of Colorado is within Colorado. So the court's kind of hysteria over, my God, we could have all sorts of different ballots. Number one, the ballots in the different states are different anyway, as you're pointing out. I mean, oftentimes third-party candidates get on some, but not all 40, 50 state ballots. That's Ralph Nader, Pat Buchanan, Jill Stein, they were third-party candidates. So why are they so exercised about this? Again, it goes back to my belief that they're an empire and they just want federal government to be supreme in all aspects that relate to running empires. Now, with regard to the Kennedy situations, it's kind of unique because Kennedy has not sought to remove himself from all of the ballots from which he was qualified. He's only doing them in the states that he thinks are battleground states and where his removal from the ballot could aid Trump. I'm sure he's marching to Trump's.
And he's not withdrawn. He suspended his campaign. He hasn't ended his campaign.
Yeah. So he
suspended his campaign. So for me, it's not the issue of his behavior or not. I don't want to judge his behavior one way or another. For me, it's an interesting constitutional question. It raises about, you have someone who was still running for office with not actively pursuing that office, but who has not removed themselves from all ballots. So clearly it's not a federal issue because it's trading into state by state basis.
That's right. And you may know, Jeffrey, that in Michigan came to the opposite conclusion of North Carolina. They told Kennedy, you can't take your name off. So it just shows to think that there's intellectual tidiness in the law is a fantasy. No. There are inconsistencies all the time. But the underlying theme that I say is quite troublesome is, well, ultimately, when we believe that the empire is in jeopardy, we're going to rule for empire and the federal government can do whatever it's want. Maybe at the edges, we'll let states do a few things. But if the empire is in question, no, empire is going to win. Feds do whatever they want.
No. What do you think about these possible scenarios? What if Colorado says we kept him on a ballot? You forced us to a Supreme Court, but you can't force us to certify him in case he wins Colorado because we still believed he doesn't really deserve to have been on the ballot. So the state electors decide that while he might win in the state, he should have never been on the ballot, that the Supreme Court forced somebody that the state didn't deem should be on the ballot. And therefore the legislature determines from its own judgment that they can they don't have to certify because they don't believe they were forced to do something by the federal government that the federal government, didn't have a right to do. So what if there's an effort? So it'd be interesting to see, if there's an effort, and it'll also be interesting to see, after the election, what Merchant might decide regarding sentencing of Trump and whether that sentence would trigger anything that would give grounds for anyone to not certify Trump given that sentence, or even the discovery that the prosecution would be able has apparently will present at the end of this month, that Judge Chutkan is going to seem to allow. I don't know how much of it will be public, but while the trial will not start, it seems like she's going to be able to allow the prosecution to present evidence that so far the public has no knowledge of. And the questions will be, there's something in that evidence that some states might deem or some electors might deem as disqualifying, and therefore another reason or excuse or pretext or whatever you want to describe it for not certifying Trump. And the other point that I'll raise, and then I'll let you answer, is supposedly the electors are the coordination of electors are supposed to be done within the states. It was clear that from some of the evidence that has been made public is that this quote fake elector scheme was masterminded in the White House and managed from the White House, and that the federal government does not have that role in sabotaging who works at electors on the states. So I said a lot, so maybe you can address some of the points that I've raised in the questions and doubts.
Sure, wonderful question. Start out with Jeffrey. You can't if a state doesn't want to cast electoral votes, it doesn't have. You can't get a court order. If it wants to sit it out, can sit it out. The constitutional requirement is a majority of all electoral votes, and if that isn't satisfied, then the selection of the president goes to the House of Representatives, where each state has one vote. But if Colorado, after the Anderson decision, decided this doesn't make any sense, it could. There's no requirement that electors be elected by popular vote. It was 1857 was the last year in which a state, South Carolina, still had the electors elected by state legislatures. That was the custom in the early years. Then it tilted towards popular vote as we so-called democratized, if you will. But there's nothing that would require Colorado to stick with the ballot process. They could change the law and say, we're going to have the state legislature decide electors. State legislature could say, as far as we're concerned, we're not going to vote for Trump because we think he's guilty of insurrection, vote for some other candidate. So that's always a backup. As it is constitutional, whether it's politically feasible, I don't know about the politics of Colorado. I don't know whether that's true or not. Now, with regard to it is possible, and the Supreme Court has upheld the right of states to require that electors vote as according to the representations of their loyalties at the time that they were elected. Now, what about this case of fake electors? Well, you're surely right that under the Constitution, the president has zero role in the electoral college process, and indeed zero role in the counting of electoral votes. That task, the counting, is entrusted to the Vice President of the United States under the 12th Amendment. He counts the votes, doesn't second guess them. He counts the ones that have been certified by the states, which underscores how odd it was for the Supreme Court to suggest that this fake electoral scheme was somehow presumptively protected, if not completely protected by presidential immunity, when what before the court was the undisputed evidence from none other than Vice President Mike Pence himself, counting that on the morning of January 6th of 2021, Trump hectored him and said, Mike, you have to choose between me and the Constitution, namely recognizing by Trump there was a difference between him and the Constitution. And what he was being asked to do was not what the Constitution required. And yet the court, as you pointed, well, that's still going to be covered by immunity. I mean, I don't even know how you get your mind about that. It's like squaring the circle. When if Mr. Trump knows there's a difference between what he wants and what the 12th Amendment requires, you'd figure the Supreme Court could understand that too, but apparently it didn't or wouldn't understand it. Anyway, we have many, many complexities that can arise here. And I apologize to the audience if they can get confused about all these different processes, but they're very important because ultimately the rule of law depends upon process, procedural regularity. You come back, you have to have rules of the game. You can't change them in midstream. And that's why it's important to pay attention to all the issues you've been raising, Jeffrey, about state issue, federal issue, who decides, because we have to be firm and even-handed in how they apply. It can't be one rule for one party or one individual and not for another. Otherwise, we're back to King George III and before the 1776 revolution.
Oh. Bruce, where can, besides watching Fine Points here and the conversations that we'll continue to have, where else can people find you and read? Where else you published? Where else do you put out information so people can know
If you
more
want,
about you and people become more familiar with your writings?
okay,
So
I have 61,500 followers on Twitter. That's at Bruce Fein ESQ, and then I have a Substack column, Bruce Fein at Substack.com. And then I have my 100 books that you need to read in order to be a citizen of the type you've described. You can watch that. It's on my my website at www.lawofficesofbrucefein.com. You'll be able to get access to virtually everything I've written over the past 20 or 25 years.
Well, thank you very much. As always, it's always an educational and interesting experience having a conversation with you. I greatly appreciate it.
Thank you, Jeffrey. Thanks the audience for paying attention. Have a wonderful day.
Bye.
All right. Bye-bye.